Now our topic moves to administrative law. To begin talking about administrative law, we must have some notion of what administrative law is. The word administrative in administrative law has a special sense. It has a special connotation. It does not refer to stuff like business administration, but rather it refers specifically to the public administration. And what is the public administration? Well, the public administration is an exceedingly broad domain. To get an idea of its contents, one good way to start thinking about it is to go back to the familiar legislative, judicial, executive division of the trias politica. Typically, my students have no trouble in explaining what is the legislative function and what is the judicial function. The legislative function makes the laws, it legislates. The judicial function comes to judgment into specific cases in trials. But what does the executive do? Well, that is almost like a trick question, because a good answer there may be something like it does everything else. What is everything else? That is running the state, running the public service from A to Z. And that is a very big and large range of things that it can do. This is of course connected with the great expansion that occurred in the domain of state action in the 20th century. So the 20th century saw a shift between a night watchman state, that is a state whose only role was to solve conflicts between citizens and ensure respect for the rules of the civil law and the property law and so forth, to the welfare state, which is a state that is charged with ensuring that citizens have the provision of certain basic goods and services. You can imagine that whereas the night watchman state of, let's say, of the 19th century would have essentially been in charge of the police, the military, and the courts, and making sure that disputes between private parties are settled in a peaceful fashion, the welfare state has an enormous variety of functions that range from setting the education curriculum to arranging admissible radio frequencies, setting shielding requirements on electronics, managing the tax collection, managing water provision, and providing for the health and safety inspection of food, restaurants, cafeterias, and so forth. The welfare state has all of this in its portfolio because what citizens have come to expect from the state since the 20th century is much more than simply keeping the peace. That is not enough. We want the state to give us some degree of quality of life, that is, of welfare. And then administrative law is the area of law that covers the work of the state in this exceedingly broad domain. Now, when I said that administrative law essentially is the law of the executive function, I must make a distinction because otherwise what I say would be incorrect or imprecise. Administrative law covers all the large portfolio of the welfare state and also, of course, the police function of the traditional night watchman state, which has been expanded upon but not removed. But it excludes what are traditionally have been called acts of prince. The executive also has powers, for example, to wage war and to establish diplomatic relations. Traditionally, these powers have been treated differently from the administrative powers. It's seen that the executive has at least two dimensions. One dimension, which is the day-to-day running of the state, which is covered by administrative law, and another dimension, which is more of a pure political prerogative, and that's why it's called acts of prince, which is issues like waging war or setting on embassies and consulates, and traditionally this latter function is considered to be special and is seen as more of a pure prerogative of power and is not covered by administrative law. Just like when we saw criminal law being a sword and a shield, that is to say, both providing the channel through which the punitive power of the state is exercised and providing protections for citizens vis-a-vis the exercise of this power, we can also say that administrative law has this dual function, this dual dimension. It gives with the right hand and it takes away with the left. It has an enabling function that gives privileges and competencies to the public administration, and it has a safeguarding functions that gives rights and protections to the citizen when they are the subject of the work of the public administration. So in the end, we have a lopsided balance. The administrative law gives certain rights to the state and gives also certain special responsibilities to the state. And the end result is some form of equilibrium. So in this lopsided balance between privilege and responsibilities, let's start with the privileges. The public administration can do really quite a lot of things to you that a normal citizen cannot do. So the relationship between the public administration and you is quite different between the relationship between you and another normal citizen. The public administration can, for example, put fines on you because you do not do what you were supposed to do. It can establish investigations, make a file on you, and try to make an assessment of whether you are a responsible business or a responsible restaurant owner or so forth. The administration can grant you licenses or terminate licenses. For example, grant you a license to make a certain building, but if you do not comply with the building parameters, terminate that license. The public administration can even expropriate private property, although this is more of a special procedure because now the judicial supervision here is a bit higher than in others because private property is highly protected. And the public administration, it's much more normal for it to have monopolies. So whereas in the traditional civil market, a monopoly would be either undesirable and illegal or extremely exceptional, in the provision of public service by the public administration, the monopoly is a very normal situation. So when they provide water services or electricity services or gas services, it's very common, it's not universal, but it's still very common to see that the public administration operates in a monopoly fashion. And then you can see in this its privilege vis-a-vis what would be the power of a normal civil person. Now, the privilege that administrative law recognizes on the side of the state have actually a special form that I want to focus on now. So if you imagine that this is the trias politica, and here we have, let's say the legislature should be the apex because it represents ultimately the people. Here we have the judiciary, and here we have the executive. The funny thing about administrative law is that administration becomes, in a certain way, a state within the state. So imagine a triangle, another trias, appended to the vertex of the top triangle. So the executive has, in its own sense, a properly executive function, the day-to-day policing, but it also has delegated legislative power and delegated judicial power. And that's something that we can see, for example, when the executive is granted the power to make regulations or granted the power to establish fines and address complaints. In fact, that's a very, as we'll see later, the power to address complaints is one that you first have to complain against the executive before going to a full judicial review. It's not only that the executive has the privilege to act like a state within a state. I would say that in terms of sheer power and size, the yellow triangle down here, it's actually bigger than the classical trias politica. The branches of the state are not all of the same size. In terms of legal power, of course, the executive is subordinate to the legislature and the judiciary. But in terms of actual political power, actual real life might, the executive is easily the strongest branch. And the reason for this has to do with the change in how government works now that we live in the era of the welfare state. Not only has the welfare state expanded the functions of the state, it has also made the functions of the state essentially technical, technocratic in nature. So as you may imagine, the day-to-day business of running a welfare state is one that needs scientists, engineers, economists, uh, and not just lawyers and not just politicians. Politicians would not be able to decide what's the acceptable limit of sulfur that may be present in tap water. Politicians are not fit to decide which forms of crops are environmentally friendly and which of them represent a monoculture. And politicians are not fit to decide how the budget should ultimately be balanced. They can partake in the decision at a very high level, but the details of the decision will need to be settled by experts. And that is something that has been handed over to the executive branch. The executive branch is where, instead of just having politicians as the legislator or judges as in the judiciary, you actually have the public administration, the public servants, which will be a specialist in environment, population, water, construction, civil works, and so forth. So because of the technical nature of the role of government nowadays, the legislative branch has found it both convenient and inevitable to say, okay, I will give you, as a executive branch, I will make the legislation giving you very general framework for antitrust law. But within that very general framework for antitrust law, for telecommunications, for internet provider services and so forth, within that very general framework, I actually have no choice but to ask you to make the detailed regulations, the regulations that will say exactly what is the type of bandwidth that an internet service provider must give, what is the type of shielding that electronic equipment must have, and so forth. So the legislator is the one that will have the power to make these specific regulations within the legislative framework granted by the legislature, because it's the only one that has that scientific competency. And for that very same reason, for reasons also of expediency and knowledge, the legislator will say, if people are unhappy with the regulation, if people are unhappy with the decisions because of their technical nature, I first want them to be discussed by the experts. So if you think that the decision to not to authorize a certain test for corona because the rate of false negatives is too high, then that decision, if you're unhappy with it, the administrative law will have you first discuss it with a pseudo-judicial procedure in the public administration. That is to say, first you will have to complain to the public administration itself, because they want first to have the view of the experts. The experts, let's say, on probability, or the experts on biology, before having that go to a court where that's going to be addressed by a normal judge. So because the administrative law has this extremely wide scope, that it creates, let's say, in the privilege it gives to the executive, creates something like a state within a state, it's a good reason to say that this area encompasses a very high degree of actual political power. Moving on to the side of the protections. So we say that we have this lopsided balance between extra rights granted to the administration, but also extra protections granted to the citizens. We will see that the administration has special powers, but it also has special responsibilities. I will not go through all of them because I think the book does a very good job in explaining them. So I will just highlight a few of them. So for starters, the public administration has a constraint of legality. If I ask what a citizen can do, the classical answer is that a citizen can do anything that has not been prohibited by law. When we ask what the public administration can do, the answer is the opposite. The public administration can only do exactly what the law enables it to do. This is the responsibility of staying within the sphere of legality. The administration has special powers, but it can only exercise them exactly in the ways that the law has authorized it to act. A second protection is the provision of détournement du pouvoir, or deviation of power. This is something that happens when the administration behaves textually within the limits of its legal powers, but it does so for ends that are not the authorized ends. So for example, imagine that I ask for a license to operate a pizza restaurant in the Friedhof. The administration denies me the license. Denying me the license is part of its prerogatives, its power to grant the license or to deny it. So let's say it's in principle legal. But the reason that the license being denied is because that the public administration wants to protect a friend who also has a pizza restaurant in the Friedhof, and they want to protect him from competition. This would be detrimental for war. The public administration's power is being used to serve ends that are not the proper aims of the administration, but let's say in this case, private aims. A third requirement is proportionality. Administrative action in general must be rational. It must be reasonable. And irrationality or reasonableness in administrative law is typically studied through the language of proportionality. An administrative measure has to be proportionate to the aims it tries to achieve. To put it colloquially, the medicine must not be more hurtful than the sickness. So for example, imagine that for the aim of protecting the environment, that is, let's say, protecting a certain endangered species of turtle, the administration prohibits all fishing in a certain part of the sea. If the tortoise can also be protected, if the turtle can also be protected by requiring fishermen to use special nets through which fish are caught, but turtles can escape, then it will be disproportionate to issue a blanket prohibition on fishing, which will impact the rights and interests of fishermen if let's say a less costly measure would be technically feasible. A fourth requirement is the requirement of motivation or reasoned judgment. When the administration grants you a license, or especially when it denies you a license, when it interacts with you through some legal channel and says, for example, that you have to pay interest on your taxes, it must give the reasons for its decision. This is simply in parallel to the concept of reasoned judgment that we already saw in procedural law. Of course, giving reasons for your decisions is important on an ethical level because it's part of treating you as a responsible person, that I can I direct myself in a reasoned manner, but it has also pragmatic importance in that if you don't know the reasons for a decision, it becomes much more difficult to challenge the decision later down the road. And of course, the acts of the administration must ultimately be reviewable by courts. So, of course, we have seen already that the administration has its own quasi-judicial service, and that most of the time you are required to first raise a complaint vis-a-vis the administration before going to court. But it's a natural right of citizens that if that complaint is not settled in a satisfactory manner, you can still go to the higher court. And this right to go to court is something that is explored in the impugnation process in administrative justice, which is how you can ultimately get out of the small triangle, well, it's not small, let's say, of the subordinate triangle, and go to the higher triangle of the full trias politicas and bring your complaint against the administration into a formal judge. This impugnation process will typically have to start by an act of the administration. Acts of the administration are typically classed in juridical acts or factual acts. The phrasing here is not very happy. Translations of these words in English is actually very non-idiomatic. But the juridical act is essentially it does not mean judges, it just means that the administration has formally called you. For example, if you get a letter saying from the tax authority saying that your taxes are overdue and that you're going to have to pay interest and a fine, that would be a full juridical act. You have essentially been called by the administration. A factual act, by contrast, will be something that the administration does to you and affects your rights and interests without you being formally called about it, without being formally notified about it. So for example, if the administration simply digs a hole outside of your house because they want to see whether they want to change the piping or not, and the making of this hole creates an enormous inconvenience for you, then you want to complain about this, you haven't been notified. It's simply something that was done factually without any sort of formal legal call. That would also be something that you can complain about, but that's typically called factual act in this very unhappy translation from, let's say, continental European languages to English. To move on the impugnation process, it's generally normal, it's almost without exception, that you first have to complain to the administration itself. And that's something that I have already mentioned. So first you have to do this mini judicial procedure. It's not really judicial, let's say quasi-judicial procedure of raising a complaint, for example, with the tax authority or with the environmental agency or with the municipality, and saying, I am unhappy that you say that I haven't paid because I did pay, or that you're unhappy because of the hole they've made outside your house. And then this will go to the administration's own procedure for solving disputes, and they will come to a decision. This is not going to be an impartial procedure, because the administration is not impartial. The administration defends its own interests. But the administration will nonetheless try to solve the matter in a way that you consider to be satisfactory. If this doesn't happen, then you're allowed to go to court to complain. And this complaint in continental Europe, it will typically be done to a special court, because the administration has this important standing as, let's say, the state, and being behind the public interest, it has amongst its privileges is that it will litigate only in a special higher court, for starters. This judicial complaint can happen in two big ways in the continental tradition: in the so-called recours objectif and the recours subjectif. The recours objectif and the recours subjectif are just these traditional pathways to complain about something that the administration has done to you, either through a juridical act or a factual act. Traditionally, they work in this manner, and they serve to illustrate a general theoretical point, which can be called the equilibration between admissibility and remedies. And that sounds very abstract, but I will explain what it means. The recourse objectif is one where you complain as an interested citizen defending the integrity of the law. So if I complain on a recourse objectif because they made a hole outside my house, the way in which this complaint will be phrased is, I am just a citizen and I've seen that they are doing something illegal here because they're making a hole for no reason, and they're surely spending public money without justification, and just as a concerned citizen, I want the court to look at this. Then, because this is the type of claim that you're making, you're just an interested citizen, you can say that standing is going to be very broad. So we already have the concept of standing. Standing is a little bit like saying, do you have standing? Is like saying, is it pertinent that you bring this case? Under recourse objectif, standing is broad. Who can bring a case? Well, any concerned citizen. Any citizen that is concerned with the integrity of the law. So you don't have to be anybody special. And the time limit for you to bring this sort of complaint will also be very flexible, because you're just trying to say, you're just trying to assess whether this is legal or illegal, and that is something that is interest for everybody. On the flip side, because the claim is phrased in this manner, so I'm just interested in the law, the remedy, that is what you get at the end of a recourse objectif, will be narrow, will be restricted, will be limited. So if you win, if it's shown that the hole that was dug outside your house was actually illegal, what you may get is something like an order asking them to stop digging the hole and to fill it back up. Or that is, to put it in a more formal sense, the elimination of the administrative act that is illegal. But what you're not going to get is compensation for the harm that has been caused. The recourse subjective is the mirror image of the recourse objective as I have explained it. Here, by contrast, you start from a limited standing. So if they're making a hole outside my house and you want to complain, you have to show that that is indeed affecting you and affecting you personally. Who can complain in recourse subjective? Not any public interested citizen, but whoever has a legally recognized right or interest in the issue. So then you say, well, this is outside my house, is affecting my rights to my property, is devaluing my property, is affecting my interest in being able to enter and exit in an efficient manner. So that would be something like a recourse subjective. You have to show that you personally have an interest in the decision, because otherwise there would not be standing. Otherwise, your participation in the case would be seen as impertinent. But the flip side is that if you win, what can be won here is not simply the elimination of the offending administrative action, but much more than that, and essentially that is compensation. Because the court finds that your interest has been breached, the court will grant you, and you specifically, compensation of the harm that has been caused. Between recourse objective and recourse subjective is explained theoretically by academics as a general equilibration between admissibility and remedies. So the idea here is that a judicial procedure must either be wide in its base and narrow in its apex, or narrow in its base and wide in its apex. It cannot be wide on both sides, because you're trying to create this sort of balance between the different parts of society. And if the judicial procedure is simply wide in all the scenarios, it will be too unbalanced. It will be too costly either for the citizen or for the administration. Now, if it's wide everywhere, if it's narrow everywhere. Now, you essentially want to divide things equally between the interests in play by creating a form of process where things are narrow on one end but wide on another, or vice versa. And generally the idea is that you are creating this sort of fair distribution between the interests of the conflicting parties by distributing things in this manner.